When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-virus acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful.
No matter how minute
this right, no matter how minute.
He who comes to equity must come with clean hands. Hello out there, you are welcome to another fresh episode of the program Justifying Nigeria on ACNN television, reaching you from Abuja. On today's episode, our subject of discussion will be the legal concept of preliminary objection. My name is Anozechi Nomso, your anchor. It remains a statement of fact that an accused person is expected to take his plea after his charge has been read to him. However, before he actually takes his plea to the charge against him, he may wish to raise an objection to his trial, and in such circumstance, a preliminary objection has been raised. A preliminary objection is therefore a legal avenue that gives the defendant the opportunity to remind or draw the attention of the court on his concern about the charge against him. In other words, the court is duty-bound to hear the objection or objections as the case may be. What then is preliminary objection in its entirety? What are the grounds upon which a preliminary objection could be raised? What happens when any or all of these grounds are sustained and overruled? What is the position of the law when the accused refuses to plead to his charge? With me in the studio to address this and make sense of it all is Barrister Festus Ntang. He is an experienced Abuja legal practitioner, associate member, Institute of Chartered Mediators and Arbitrators, also an associate member of Institute of Professional Managers and Administrators of Nigeria, partner at Chizo Consultants. He's also an event comparer and business strategist, and also a member of Unity Bar here in Abuja. You are welcome to the program, sir.
Thank you so much.
Thank you for having you here. We oftentimes, you people go to courts and litigants will go, they will hear the issue of a preliminary objection. And you agree with me that there are some of the viewers out there who might not know what preliminary objection is all about. So to the betterment of our viewers and in legal perspective, can you explain and tell us what preliminary objection is all about?
Yes, I can, to avoid sounding legalistic,
I love
using the language of the law. Let's
come down to a layman view.
Exactly. Preliminary objection, just taking it from the word preliminary objection. So preliminary may just be something that should be done in time, early enough. So it's an objection that should be done at the beginning.
Okay.
It's an objection that is done.
So you don't bring preliminary objection maybe at the time of concluding the matter in the court?
Well, that's the beauty about it.
Okay.
That's the beauty, that even if, by the name preliminary, it should be done at the initial stages. The beauty of preliminary objection,
it can be raised at any time.
It can be raised at any time.
Okay. But you are trying to bring it down to layman's view.
Down to layman's
Please continue
view,
with explanation.
to the fact that, yes, it should be done early enough, preliminaries, beginning, you're just getting, the matter is just instituted, you're just noticing, then it's a preliminary objection.
Okay.
Yes.
So it comes on that,
it should come early.
But not necessarily, it might not come at any time. Now, when we talk about, you just define what preliminary objection is all about. Are there grounds upon which that preliminary objection could be raised? What are the things that will happen when a client, through his counsel, will raise a preliminary objection?
Okay, so first of all, the purpose of a preliminary objection is to draw the attention of the court or question the jurisdiction of the court. So what you are objecting to most of the time is saying this court does not have jurisdiction to hear this matter because...
In a nutshell, for our viewers there, what is jurisdiction? Because these are another legal term.
Okay, yes, it's another legal
so that we understand.
Jurisdiction may just mean power or right.
Okay.
Yes, it may just mean, okay, I don't have the power or I don't have the right to be hearing this matter.
So when you're talking about jurisdiction of a court, maybe the power, whether he
Yes.
has the right or power to hear the matter.
Yes.
Go ahead, sir.
Yes.
Okay.
So the preliminary objection is raised so that the attention of the court can be drawn to the fact that you don't have jurisdiction to hear this matter. So usually what happens is, like I mentioned, it's usually done at the beginning, but in an event where it is done probably mid-trial or even before judgment, even after judgment, the beauty about it is preliminary objection can actually be raised on appeal.
Even on appeal?
Yes, a preliminary objection can actually be raised.
What about on judgment day? Can it also be raised on judgment day?
Yes, it can actually be raised on the day of the judgment.
Indeed, that's the beauty of it.
That's the beauty about it. The idea is we may want to ignore, or we may want to say probably counsel did not know at the time and probably realized just before judgment and brings a preliminary objection. So he's brought a preliminary objection. The rule is once a preliminary objection is raised, the court will stop every other matter to address the preliminary objection.
Must. That's the procedure.
Stop. Yes. It will stop.
No matter how critical the matter will be, the substantive matter
is. Yes, it will stop hearing the substantive matter and deal with the preliminary objection. So what the court will do in that instance is to assume jurisdiction to determine if it has jurisdiction or not. So it has stopped hearing the substantive matter and now says, I'm going to hear what your argument is to determine if I have jurisdiction or not.
No, counsel, in a criminal charge,
Yes.
we know oftentimes there is what you call a trial within a trial.
Yes.
And I know that you legal luminaries usually say that trial within trial, once it's being raised, the substantive matter will be left, no matter whether it's murder, no matter how critical,
Yes.
and looked at the voluntariness to ascertain how voluntary the confessional statement is.
Yes.
Can you see that it's somehow the same thing with this in civil matter? Because you are saying that preliminary objection, once it's being raised, like that of a trial within a trial, once that's voluntariness of confession is being raised,
Yes.
that they will stop the substantive matter. Can you, is it likened to the same thing in a civil matter? Is it almost the same thing?
I would not liken it.
Why?
What I would say in this instance is a preliminary objection is challenging the jurisdiction of the court. You are saying this whole process should not be here. This court should not even hear this matter. We shouldn't be in this court. Now, for a trial within trial, we are in court. The court has jurisdiction. What we are challenging is, did you make your statement voluntarily? That is what we want to find out. So yes, we stop all the other processes and go into the situations, the circumstances that warranted or that brought about the accused making his statements.
Okay.
Yes. Then, well, yes, I would have to mention the classical case. It's a classic case. That's,
okay.
Yes, but we in the profession we say
locus classicus. That is where the principle started.
Where the principle is established. You know, it has also been established in other cases, but the most popular of them will be Madukolum against Nkem Dilim.
Okay, in terms of jurisdiction.
In terms
Please
of
tell us what, how,
jurisdiction.
so that you'll be able
Now,
to explain
in that matter, the court held, you know, that for the court's jurisdiction to be properly invoked, there are three conditions that must be.
Three conditions
that must be fulfilled.
Which are?
That the court is properly constituted.
Okay.
That the court is properly constituted, and this, you know, for example,
Counsel, can you list the three, then
Yes.
take them one by one?
Okay, yes, that the court is properly constituted.
Number one.
That's number one.
Yes.
Number two, that there's no precondition that must have been fulfilled before coming to court.
Okay.
There's no precondition that must have been fulfilled before coming to court. And then number three, it's what's the third one? I'll remember the third one.
But then
let's
start
let's
the
take,
constitution of it. Yes.
Let's take now for example, the Court of Appeal sits 3 justices.
At
To
least.
hear at least 3 justices. They won't sit less than 3 justices to hear an appeal matter.
Now, Counsel, you use the terminology justices.
Yes.
But when you are now making statement before now, the High Court used the word judge.
Yes.
Are they two different things? Why educate our viewers?
Well, yes, in the High Court, they call them judges.
Okay.
But once you go higher, that's to the Court of Appeal and to the Supreme Court, they are called justices.
Okay.
So you still have justices. They are called justices of the Supreme Court, justices of the Court of Appeal.
Then High Judge.
The High Court is called a judge.
Okay.
Yes, it's an elevation.
Elevation. That's right.
It's an elevation.
So now go ahead.
So
once it's that of Court of Appeal, there must be 3 at least.
Yes, there must be 3. The court cannot sit less than 3.
So however, however,
there are situations where the court would actually sit 5 justices.
In Court of Appeal?
Yes, in the Court of Appeal, they would actually sit 5. And those situations are different. For example, the Court of Appeal is a Court of Appellate jurisdiction, which means that you don't have, if I slap you and you want to go to court, you will not go to Court of Appeal first.
Okay.
You probably go to the High Court.
Counsel, this is becoming interesting, but you're going to explain all this when we come back for break. Please, viewers, do join us again. Hi, you are welcome to the speaker on ACNN television reaching from Abuja. The speaker is a platform by which we discuss some topical issues in the polity. On today's segment, we are going to be looking at conducive Nigeria or an unconducive Nigeria. My name is Anozie Chinomso. A conducive environment is an environment that is helpful, which tends to promote internal and progressive development. When an environment is conducive, it means that such environment is devoid and free from unnecessary rancor, wickedness of hearts, and unwarranted sentiments. On the other hand, an inconducive environment produces envy, jealousy, underdevelopment, backwardness, and stagnation in economic growth. With the kind of inconceivable and inconducive things happening in Nigeria, I'm moved to ask on whether we are living in a conducive Nigeria or an inconducive Nigeria. When investors cannot come to Nigeria to invest, is a typical example of inconducive Nigeria. When Twitter decided to establish their office in Ghana and not in Nigeria, the so-called and self-acclaimed giant of Africa is another example of an inconducive Nigeria. Did I just say giant of Africa? Giants indeed. When Nigeria failed to be giants in education, solid healthcare system, strong infrastructure, security of lives and properties, rather have a high scorecard of becoming giants in kidnapping, banditry, terrorism, Boko Haram, impunity, breakdown of law and order, incessant killing of innocent and helpless citizens, and massive genocide and homicide is a perfect picture to believe that we are living in an inconducive Nigeria. In a situation where Nigeria, especially the political class, uses any available opportunity to loot the treasuries of this country, is another pointer to the fact that we are dwelling in an inconducive Nigeria. Where a minister of the Federal Republic of Nigeria comes out on a national television and told the world that doctors will now be treated on no work, no pay basis when some of these doctors are being owed for more than 14 months is another way of showcasing that we are living in an inconducive Nigeria. When borrowing from an outside consortium has become a major source of income for government, thereby putting the generations yet unborn into perpetual slavery of debt, is another establishment of the fact that we are living in an inconducive Nigeria. When kidnapping have turned to be a lucrative job, more than the people working in an oil company, when bandits are being celebrated and rewarded handsomely for killing, molesting our children, and raping our women, and the government is totally silent and mute about it, causes a monumental decay to Nigeria. When security of lives and properties cannot be guaranteed in Nigeria anymore, showcases a total failure of Nigeria. When no sector in Nigeria is working, when our leaders have become cheaters, we are nothing but praise in their hands. When the government spokesmen continue to see virtues more than vices of their masters, is also a contributing factor towards an inconducive Nigeria. How can it be? Just tell me that nothing seems to work in Nigeria. How can it be that Nigeria has become a hunting ground where one rebel group is being planted and germinated almost on a daily basis? How can it be that in Uganda they are celebrating solar-powered buses through their innovation, and we are celebrating how kidnappers release their captives after paying ransom? How can it be that Morocco, they have the largest solar plants in the world, and Nigeria have the largest killing henchmen and unknown gunmen? How can it be that in Kenya, they have the largest wind farm in Africa, and Nigeria is celebrating the highest number of rapists? How can it be that in Ghana, arrangements are being made to enhance the quality of education and provide free transport system, and Nigeria, the so-called giant of Africa, is in the business of returning political thieves back into office? And that was why they are doing everything possible to ensure that they remove electronic transmission of election results as contained in clause 52 sub 3 of the new electoral amendment bill, so that they will continue to benefit from their evil acts and deeds, grafts and corruption. Nigeria indeed has an affinity of doing that which is wrong and refuse to do that which is good. In order to justify Nigeria, I therefore speak. Until we all begin to see the current dilapidated and inconducive state of Nigeria and begin to do something about it fast, ensure that character and honesty becomes our watchword, endeavor to change our attitude towards things, try as much as possible to take responsibility in order to bring the desired change, where our environment will be free from hostility, acrimony and unwarranted fear, and thus bringing development, innovation and creativity. We shall continue to live in an inconducive Nigeria instead of a conducive Nigeria. My name is Anozie Chinomso. I just want to speak. Glad to know that you are still there, our esteemed viewers, and we are still here in the studio with Barrister Festus Ntong. Counsel, before we went on a break, you have established the three conditions on the locus classicus of Madocolum, and now you are about explaining them. Yes. Please take it up from there.
Yes, and we had already explained that the court must be properly constituted, yes, and that there must not be any pre-action or precondition to instituting the action. And then the third one is that the subject matter must be within the jurisdiction of the court. Okay. Remember, we have described jurisdiction to mean power or right of the court to actually hear that particular subject matter. Yes, so we had described the Constitution that if the providing rules or the enabling rules of the court says you must sit 5, you must be 5.
Okay.
If you are less than 5,
yes, what happens?
You don't have jurisdiction to hear because you are not properly constituted.
So anything determined there could be quashed on appeal?
Yes, it's actually null and void.
So now you are telling me there are 3 justices in Court of Appeal, yes, depending on the and once they are less than 2 or 1, whatever thing there is null and void.
It's null and void, yes.
No matter how beautiful the judgment is.
No matter how eloquently delivered it is.
This is interesting.
It is actually null and void.
So that's number 1 condition.
That's the first condition. Then the second condition is that there are no preconditions. In other words, I'll use a civil matter to explain this.
Okay.
I'll use a civil matter. For example, in a civil matter, we have an agreement, we have a contract that says that if we have a disagreement in this our transaction, before we go to court, we must attempt arbitration. We must attempt mediation, which are alternates. They are alternatives to litigation, which is actually going to court.
Is that what people call ADR, alternative
yes,
dispute resolution?
Dispute resolution. Oh. So if we have come to that agreement, parties are bound by the agreements. Oh, so we have come to that agreement. Having come to that agreement, we had a falling out. I cannot just jump to court. So having had that agreement, we must actually, try to explore the options available based on that contract. So if we go to court without
first going
doing all of those,
whatever decision there is not void.
It's actually null and void. And at that instance, whoever institutes, the defendant can actually raise a preliminary objection saying this court does not have jurisdiction. Then the third one, I think, okay.
Yes, that's the third one. This is the second one. Yeah, the third one.
Then the third one is the subject matter.
Okay.
So we can now use back to criminal matters. For example, we see that in the case of treason, for example, the Federal High Court has jurisdiction to try matters of treason. So the High Court cannot try matters of treason. So if you institute a
customary courts also don't have.
No, you don't have. So if you institute a matter that the subject matter is treason or treasonable felony, or such nature in the High Courts, the court doesn't have jurisdiction to entertain that matter. It is actually supposed to be the Federal High Court. So these are the three conditions that have been laid down before the court's jurisdiction can be properly
constituted.
Yes, and then we know that yes, the court has jurisdiction to now proceed.
Now, counsel, if any of these grounds, let's say it met up with the two, you listed three, any of them is not found, will the court also not have the jurisdiction? Must they run concurrently?
The conditions run concurrently.
Three of them must be met.
They must be met. They must be met. So the court can sit 5, but it's not in the subject matter. The court can be properly constituted. It's not in the, you have not met the precondition. The court's jurisdiction cannot be properly invoked at that particular point in time. Yes. And then usually for criminal matters, most of the time what we have as reasons for preliminary objections are a defective charge.
What do you mean by that?
A defective charge is you are bringing an accused to court. There's a document, it's a charge sheet. You write his offenses. Number 1, on the 1st of July 2015, you committed this at so time, properly detailing, so that the accused person would be able to understand what
you are reading for
you.
So
usually, where there is a defective charge, I can object. And my lord, my client is unlikely to understand this. I object to it because.
And it's enough grounds.
Yes, it's enough grounds. And once this charge is struck off or struck out, there's no charge against the accused. That's
now, counsel, in a situation now where an objection is raised, for example, for your clients, and the court either overrules or sustains. There are two questions I'm asking you. One, what happens? Take one. If the court sustains it, what happens? If the court now overrules that, or you say, cancel, objection overruled, what happens?
Okay, so I'll take the overruled.
Okay.
When this preliminary objection is overruled, it means, therefore, that the court has seen that it actually has jurisdiction to hear this matter. Meaning that the conditions in that Nkem Dilim and Madukolum that we mentioned,
all of them
have been met. Those conditions have been met. There's no other issue that is bothering or that is coming out that would make the court not have jurisdiction. And the court says, I'm overruling this objection. The court has jurisdiction.
So they'll go ahead with the matter.
Hear the matter on its merits.
Before you entertain the other one, suppose in the eyes of the counsel representing the clients also think that they don't have the jurisdiction, but the court on their own sumato says they have, can he appeal?
Definitely, yes, he can appeal. He can actually appeal that particular ruling. He can appeal that ruling, even as far as the Supreme Court.
That's the position of the law?
Yes, he can appeal. He can appeal, but appeal is, we have appeal as of right.
Yes, and of course.
Appeal as,
now, when it's now sustained, you talked about overrule. When that objection is now sustained.
When it is sustained. Yes. When it is sustained, it just means the court doesn't have jurisdiction. And I think it depends on the court. For example, in the High Court, say we take High Court of the State, High Court of the FCT, or High Court of Akwa Ibom State, for example, the rules of the court does not provide for what we call transfer of cases. So what happens is the matter will be struck out.
Okay.
So in other words, the court is telling you, go and institute it in the proper court.
Okay, once it's struck, that does not mean it's dismissal.
No,
Okay,
it is not
okay,
dismissed.
okay.
It is not dismissed.
Just
You
go
can
and put your
actually
house in order.
Go and put your house in order. Go to the proper court for this matter to be heard.
Okay.
Right.
Okay.
Yes.
Okay. Council, we have a few minutes to end this program.
Yes.
Now we have seen some situation. A charge is being read to an accused.
Yes.
For whatever reason, maybe he may be a stubborn person.
Yes.
He's not happy where he's coming from, correctional center or anywhere. Guilty or not guilty? He's looking at. What happens if he chooses or she chooses to take his plea, to answer to his plea, or if he refuses to take his plea to his charge? Guilty or not guilty? What happens?
If he refuses to plead,
yes,
the position of the law is that the court will enter a not guilty plea for him.
Why?
The court will enter a not guilty plea so that the trial can commence. And you know, the position of the law is he who asserts must prove. So in other words, the prosecutor who is bringing the accused to court should be able to prove his case.
Okay, so for non-refusal of plea of the accused does not mean that he will just be sentenced like that.
No. You know, it's even interesting because even if it was in a capital offense,
yes, like murder,
and the accused pleads guilty, the
yes,
court will still record not guilty for.
Excuse me, sir.
Yes.
He please, let's not go through all this now. I'm guilty. Sentence me. The court will still.
It will still record not guilty plea and the burden to prove that the accused actually committed that particular offense. It's always on.
Now, counsel, where the accused person pleads guilty to capital offense and the court records not guilty, and the prosecution, for whatever reason, could not prove beyond all reasonable doubt, what happened? What's the fate of the accused person?
It's obvious if the prosecution cannot prove
beyond all reasonable, yes, he's discharged.
Be discharged and acquitted.
Even when he has pleaded himself guilty,
be discharged. The prosecutor has not been able to prove.
So what he pleaded is immaterial based on the trial of the court.
You know, the impression is probably he has been influenced to take that plea. Probably something has happened in the background. Probably someone has come to him, don't do this, you know, something like that. So the impression is, you know what, it is better for 99 guilty to walk free than one innocent to be incarcerated. Yes. So the court will say, okay, I record not guilty for you, let the prosecution prove its case. And definitely, if the prosecution has a good case, definitely he'll be convicted. But in the event where the prosecution cannot prove his case, which we've seen numerous times, he'll be discharged and acquitted.
Where the prosecution cannot plead and prove his case, the accused person will be discharged and acquitted. We want to appreciate you, sir, for coming. And you have really done justice to this. And I pray when next we call you oblige us out of your busy schedule. Thank you so much. Thank you so much. Solid and weighty grounds of objections is very fundamental and paramount in a trial. Once such grounds are established, the court is duty-bound not only to hear them, but also dispense justice in that regard. Similarly, once preliminary objection is sustained, especially on grounds of jurisdiction, it may be fatal to the entire proceedings. It is therefore advised that litigants and their legal representative, in this case lawyers, must be diligent enough in order to ensure that there is no legal loophole upon which a ground for preliminary objection could be raised and sustained. Never you forget that the applicability and ability to have a good charge before the court is dependent on the sincere and honest relationship between a client and his lawyer. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station, another fresh episode of the program. Until then, this is Objection. So wishing you the very best and bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.